Tonight, Speaker of Parliament and Electoral Commission on a firm coalition course as the Speaker stops the EC from laying controversial law that will make the Ghana card the only document for voter registration. He's dared the EC to drag him to the Supreme Court if they wish.
They cannot say they are not subject to the control of anybody, including the institution of Parliament. And I will not allow any such instrument to be laid in this House until I am briefed. Anybody who is not satisfied is permitted to proceed to the Supreme Court on this matter.
The minority is in full support of the Speaker's unprecedented step.
We will not, Mr. Speaker, accept any attempt by the Electoral Commission to disenfranchise any Ghanaian because they want to rely on an ID card which is not available to Ghanaians. And we mean serious business on this matter.
This is Top Story with Evans Mensah.
And Top Story is always brought to you by Vodafone. Now, the Speaker of Parliament is tonight on a firm coalition course with the Electoral Commission. Alban Babin today declared he will not allow the Electoral Commission to lay its controversial constitutional instrument that will make the Ghana card the only document for voter registration. The Speaker was furious. He and the leadership of the House have been kept in the dark by the EC on the matter. The EC has, in fact, already pre-laid the instrument. We are picking up a few more details on this from the Electoral Commission I will share with you pretty shortly. But the Speaker says, unless the leadership of the House have been briefed, there's no way he will allow that CI to proceed.
I have not also seen anything from the EC, and I have not been given any brief by the EC on any proposed instruments coming from them. And so I raised this some time ago. I'm yet to receive them to be briefed on it. Until that is done, they should forget about laying any such instrument in the House. Wow. I think there's been a misinterpretation and misunderstanding of the concept of independence of various state institutions or arms of government that are stated by the Constitution to be independent. The independence is in the performance of their functions. When the matter comes before Parliament, that is the performance of our function, not their function. And they cannot say they are not subject to the control of anybody, including the institution of Parliament. But at that time, that is our function we are going to perform. And we are not subject to the control of any arm of government or institution of state. So please, the EC, the Bank of Ghana, including the judiciary, should take note that their independence doesn't mean that independence has ousted Parliament from performing its functions. So if the CI is to come to the House, the proper thing must be done. Both procedural and substantive law must be followed. And I will not allow any such instrument to be laid in this House until I am briefed. And I think that is a proper thing to do, together with the House, to make sure that the right thing is done in accordance with the provisions of the Constitution. Anybody who is not satisfied is permitted to proceed to the Supreme Court on this matter. So please, it's in their own interest to proceed to have the pre-laying meetings, not only with the committee, but with the leadership of the House, before anything can be submitted and be captured by our order paper. That, I believe, is sufficient notice to all.
So that is a Speaker of Parliament there. And if you recall, the Electoral Commission had indeed gone to Parliament, pre-laid this particular constitutional instrument. That instrument, the centrally, will make the Ghana card the only document, the sole document for voter registration in this country. For what we are learning, the Electoral Commission had already met with the subsidiary legislatory committee in Parliament, and was also met with the budget committee in Parliament. They've briefed them from what the Electoral Commission tells us. And in fact, the EC says they have received input from the Committee on Subsidiary Legislation. They have returned the document to the Attorney General. The Attorney General has made the corrections and they have returned it to Parliament. The question is, now that we've heard the Speaker speak authoritatively on this, that document will not be laid, as the Speaker says, until he and the leadership of the House have all been briefed on this. I want to bring in my parliamentary correspondent in this, Kweku Asante, joins us on the telephone line right now. Kweku, so how did this come about today? Because this has been pre-laid. So what triggered the Speaker's reaction?
So Evans, it was during the presentation of the business statement for next week when the Deputy Majority Chief Whip, Honorable Frank Anodompre, did so on behalf of the Majority Leader. He intimated that some issues had been discussed at the business committee meeting, which we have had expression on the business statement. And the minority in the Haruna Idrisu was not so happy that they had agreed to bring the EC and NIE to the office of Parliament to answer some questions regarding the new CI. But that had not been admitted in the order paper. I see. So
the original point, the original trigger for this was the inability of the House to capture this on the order paper.
On the order paper, right. So according to Haruna Idrisu, the minority leader, that conversation had been had with the majority leader. There was an agreement to bring EC and NIA officials to Parliament, but that had not been done.
Mr. Speaker, there is a discrepancy in the numbers between what the Electoral Commission have registered as voters, up to 17 million, and what is on the roll of the National Identification Authority. And we hear that the Electoral Commission wants to rely on the National Identification Authority data. The primary question the Honorable Ahmed is asking is, so what has happened to the Electoral Commission's own biometric data? That today they are avoiding the use of their own biodata they collected, and they want to collect biodata from the National Identification Authority. But we need a reconciliation of the numbers, because we are very convinced that Article 42 confers a right on Ghanaians to be registered as voters by the Electoral Commission. And Mr. Speaker, the National Identification Authority is unlike the Electoral Commission, which by virtue of Article 45 says that it shall not be subject to the direction and control of any person or authority. The words are mine, including the President. But National Identification Authority is subject to ministerial control. And therefore, we want the two bodies to come here, Electoral Commission, NIA. Let us see the discrepancy and variance in your numbers, because we will not, Mr. Speaker, accept any attempt by the Electoral Commission to disenfranchise any Ghanaian because they want to rely on an ID card which is not available to Ghanaians. And we mean serious business on this matter. That right, we will jealously protect and safeguard the provisions of Article 42. So, Mr. Speaker, what the Honorable Ahmed is saying is that the two institutions must come here, and then we will hear them, and then reconcile the numbers. In fact, the Electoral Commission must further explain to this House how come 2021, 2022, Ghanaians of age 18 years have not been given the opportunity to be on the electoral roll. That's a denial of the right under Article 42. Mr. Speaker, the Constitution imposes a burden on us to protect this Constitution. So any effort by any institution to erode that right, we will resist it and resist that oppressor's rule.
So, Kweku, it appears that the Speaker agrees that there's something amiss with the approach that the EC is adopting to get this constitutional instrument laid, passed into law, and implemented. I wonder what the majority side make of this.
Indeed, the majority leader wasn't around, so Majority Chief Whip Frank Anadomprey stood instead for him. He refused to go into the substance of the matter. What he said was that as a House, they were making arrangements to get the EC and NIU officials to appear before Parliament and answer questions of the MPs. We should make it clear that last meeting, before Parliament went on break, NIU officials were in the House to answer similar questions. It appears the minority members want some more answers to be given together with the EC. So that is the assurance Frank Anadomprey, Majority Chief Whip, gave.
I don't think there's a cause of alarm. And in this House, as is practice, many occasions there are businesses that have been discussed at the Business Committee and inadvertently been left out when the business statement is finally presented. I think this is pure omission because I was at the Business Committee, just as my colleague said. It was mentioned and the majority leader gave indication that he will eventually ensure that he finds expression in the business statement. I guess it's because the report is not finally done with. So we will relate appropriately and get the report so that we can present the report duly. But speakers to programming for these institutions to appear before us, I don't think there's any difficulty. That would also be done. So I will relate properly to the chair of the Business Committee, and I'm confident that the needful will be done. I could have agreed more with the minority leader on Article 187, I think specific Clause 6. Many occasions when Auditor General's report has come up, this matter has always come as a subject of discussion. And more often, we've paid just a lip service to it. Practically ensuring that this thing is implemented has always been left undone. And Speaker, this morning related duly why still the ad hoc committee has not been formed. I want to assure colleagues that we will relate properly to the majority leader and chair of the committee.
Let's get some further clarity on this, especially the position adopted by the Speaker today. I want to bring in member on the Constitutional Legal Affairs Committee in Parliament, is Kwesi Ameyaw Treme. Thank you very much for your time here on Newsnight, Mr. Treme.
Thank you. Good evening.
I mean, give me your thoughts on the Speaker's position. He says there's... Hello, Mr. Treme.
Hello.
Yes, apologies that we had an interference in your line, but give me your reaction to the Speaker's position. He says he will not allow the Electoral Commission to lay this document unless he's briefed. In fact, challenge them to go to the Supreme Court. Does he have the authority to do that?
Thank you, and good evening to your listeners. The Constitution is very clear that any ministry, department, or agency may lay an instrument. If an instrument is laid and Parliament determines that there is some illegality or unconstitutionality about the instrument, then Parliament may annul the instrument. That is, the Parliament may not allow it to mature and become part of our laws in the country. But before we go through that process, there should be a laying or what we call a presentation, which may be done by a minister or the majority leader and leader of government business. Normally, before an instrument is put on the order paper for presentation, the business committee may have considered it or may have given an indication that in the coming days or in the coming weeks, there will be such a presentation to be done. Once the business committee schedules a business, it does not lie with the speaker, before apologies, to say that I won't allow it to be laid. The business we do in the House is led by the leader of government business. Once the business is introduced in the House, it goes to the business committee. If it finds expression on the other paper, we'll go ahead and do that business. But what we are talking about now is a very sensitive issue, registration of voters. If it is not handled with care, it can lead to so many problems or challenges in the run-up to the 2024 elections. So I think there must be cool heads around this issue. Many members or some members are calling for an invitation to the Electoral Commission to come meet either the business committee or the leadership of the House. I don't think it is a difficult thing to do. Whatever explanations that they have or concerns that people have, there may be explanations or answers. So they should be able to organize or facilitate such a meeting so that the matter is put to rest.
The Speaker of Parliament, though, talks a bit of procedure in this matter. He says to lay such a sensitive document, you have to go to a pre-laying stage. He says that includes briefing he, the Speaker, and the leadership of the House. Says that hasn't happened, and so there's no way he will allow that to be laid. Isn't he right to say that?
Pre-laying is not known to our standing orders.
I see. But he mentions it when he sat in the chair and delivered that ruling.
Yes, and that's what I'm telling you. Pre-laying is not part of the process. It is something we have evolved that because it is difficult to annul an instrument once laid, or if there is anything wrong with an instrument, you may have to call on the sponsoring organization to come withdraw it, remedy the defect, and relay. You may have wasted some time. You may not get the instrument when you really need it to work with. So, few years back, we said, why can't you bring the instrument for us to Georgia so that if we have any concerns about the instrument, you may go back, rectify whatever observations that people have about the instrument, tidy it up and bring it. There is no law that says there must be a pre-laying. And the Constitution doesn't talk about a pre-laying. But it is something that we find convenient to do. It's not binding.
Mr. Chairman, fascinating thoughts there. Let's see if your colleague on the committee, another lawyer himself, Dafia Mekbo, agrees with that assertion. Roxanne Dafia Mekbo is a member of the Constitutional Legal Affairs Committee as well. He also joins us. Roxanne, thank you for your time here on Newsnight. Pretty unprecedented position adopted by the Speaker today. He extends it even beyond the Electoral Commission. He actually says the Bank of Ghana, even the judiciary, he will no longer entertain any instrument laying from them unless they've briefed him. We're just hearing from your colleague on the committee, Mr. Chairman, an experienced lawyer himself, that the procedure he's talking about doesn't even exist or is not known by your standing orders, is not known by the Constitution. So what's the basis of this?
Okay, thank you very much, and good evening to your listeners. And my leader, Senior Chairman, is my mentor in Parliament and my former leader, so I respect him highly. Technically, I agree with the position with Senior Chairman. But he knows, he's my senior in Parliament, he knows that Parliament works with practices and conventions. Now, what our Parliament has decided to do in respect of laying of instruments is that we have introduced what we call pre-laying. The concept of pre-laying was actually adopted from other jurisdictions. What is the purpose? The purpose is that instead of allowing the instrument to come new to Parliament, and it is laid, gazetted, and referred to the Committee of Subsidiary Legislation to consider and bring a report. You are aware that pursuant to the Supreme Court decision, such instruments cannot be tinkered with by Parliament. You can't even change the letter R or the article R of an instrument if you have a problem with it. What Parliament can do by that decision is that you can either reject or adopt. Adoption means you allow it to pass after 21 days. So by practice and convention, the pre-laying process is to give the committee the opportunity to vet the content of the instrument. So where members of the committee are able to effect amendments and make proposals for further improvement before it is formally laid and referred to the committee. So it has become part and parcel of what we do officially in Parliament. So is winnowing. Winnowing may not be known by our rules, may not be known by the Constitution, by the convention and procedure. When we get to the third stage of considering a bill for purposes of passing it into law, we have evolved a practice we call winnowing. Winnowing is where there are a lot of amendments to a bill. We form a small committee to go and separate the chaff from the grain. You know, it's a scientific term where you separate the chaff from the grain. So amendments that survive after the winnowing process are easily carried through the consideration. So yes, we may, if we speak contextually, if we speak technically, we may not have place for some of these things in our statute books. By parliamentary practice, they have become part and parcel of our procedure. So Speaker is simply saying that I have heard that some instruments are before Parliament, when technically the instruments are not before us. So going forward, instruments that are intended to be laid must be vetted by the committee, and not simply the committee, but by leadership.
Yeah, I mean,
so that.
Mr. Defendant, I have an authority from the Electoral Commission. When this happened, I checked with them, and they say they've met two committees since they've submitted the CI to the Parliament. The first is the Committee on Subsidiary Legislation, and the second is the Budget Committee. In fact, they got input from these two committees, and they sent the document back to the Attorney General. The Attorney General did the corrections, and they've returned it now to Parliament. Isn't that enough?
Hold on, Evans. You see, when you say it is returned now to Parliament, to which entity in Parliament? Because we're still speaking of the pre-laying process. It hasn't come formally. It hasn't been laid formally.
But if these two committees have been met and your leadership and your members have sat on it, isn't that enough?
Hold on. I participated in both of these meetings. The one before the Subsidiary Legislation Committee, I was there. I participated fully. The one before the Special Budget Committee, I participated fully. What was discussed and agreed on was that the inputs that came from either of these or both of these committees should reflect in the final draft. So what we call the final draft will have to be brought back. Once we agreed on the content, then they now can be properly laid, gazetted, and referred to the appropriate committee so that they can present a report. Then it is allowed to pass after 21 days. This is the stage where we are with the instrument from the Electoral Commission. So if the Electoral Commission sees that they have returned the document to Parliament, I'm struggling to appreciate to which entity. Is it the Subsidiary Legislation Committee or the Special Budget Committee? Special Budget because they consider the budget of the Electoral Commission as a constitutional entity. Subsidiary legislation because the instrument is a subsidiary enactment of Parliament. So it has to go before the Subsidiary Legislation Committee. So the reasons why they appear before these two committees are varied and different. Special budget because of budget.
Yeah, but considering
they have to agree as to how much you need to be able to carry out the activities the new instrument will entail.
Yeah, but considering, and Mr. Chairman makes the point, how sensitive this document is, a document that will define whether or not people get to exercise their constitutional right to vote. Considering how sensitive the document is this approach one that will engender unity at the time that we need it the most, and really documents such as this have been laid in the House and has matured and has been debated for so long. Why is this becoming such a big deal now, with the Speaker now stepping his foot down and saying, I will not allow you to lay it? Some suggest that this is part of...
Evans,
Yes.
Evans, let's be very circumspect with the choice of words. Speaker never said, I will not allow you to lay it.
No, he said that. He said, I won't allow you unless I'm briefed, and the leadership is also briefed.
He's saying that we must go through the pre-laying process. So if there is a pre-laying that has taken place in respect of the EC's instrument, it's a matter of informing Speaker. And Speaker is not speaking only because of the EC instrument. He speaks of all the instruments that come to the House. Even sometimes you will call a member of Parliament on air and say that it is out there that an instrument is in Parliament. They tell you that they have no idea.
Finally, how do you respond to the allegation? Considering how this came about today, the minority leader was on the floor making a point, and the Speaker, of course, jumps on it. Many suggest that this is part of a ploy to just kill the CI, since the NDC has publicly declared that they are not for it.
Evans, I think that there is no such correlation. The issue is that the EC already has existing legislation that enables them to carry out any function that they are supposed to carry out without any adherence, without any inhibition. Because they have in existence CI 91 and CI 126, which empowers them to do exactly what they intend to do with the new draft CI. Because Evans, Electoral Commission can carry out its limited registration with all the requirements under law. So there should be no hurry about the draft instrument.
Mr. Chairman, let me ask you then. The Speaker has spoken, and if you read your own standing orders, he has a final say on these matters. As we speak now, his word is law. What happens now?
I don't want to believe that whatever the Speaker says is law. If what the Speaker says runs counter to constitutional provisions or standing orders, you cannot conclude that he has made a law. Yes, he has expressed his opinion on the matter. As I indicated earlier, this is a very important national exercise, and everybody must be carried along, or almost everybody. Sometimes it's difficult to get the understanding or the agreement of everybody. I am not a member of the subsidiary legislation, and I am not privy to the meeting or meetings that were previously held. So I am unable to agree or disagree with my brother, Dafema Paul, on what he has alluded to on air some few minutes ago. But if indeed there was a meeting, indeed some suggestions were made which had consensus of the meeting, then probably it is just proper that when those corrections have been effected, if they made suggestions for some corrections to be made, when they have been effected or rectified, the body that suggested that you correct, you bring the document back to them for them to see that what the meeting agreed on or had consensus around have been factored into the document. Back to pre-laying. You see, when you say that Parliament is seized of a document, it is only when the document has been introduced at the plenary. So pre-laying means that document is not before Parliament. But as I said, over the years, we have come to realize that it is better to see the document, make suggestions for some rectifications to be done before it is properly or legally laid in Parliament. So there's nothing binding for anybody to say that if there's no pre-laying, there can be no laying. That is where my problem is. It is a practice that we have evolved, which has no expression in either the Constitution or in others. But we think that it is convenient, something convenient to do. But it doesn't mean if it is not done, then the proper thing, the legal thing cannot be done. So, winnowing, yeah, you spoke about winnowing. It is a practice that I think the majority leader initiated. But winnowing is done when a document or a bill is going through consideration. So it's a document that is already before the Parliament. And then a few people decide we spend more time after parliamentary hours to go through the document and make suggestions to plenary so that we don't waste too much time in doing the cross-by-cross consideration of the bills. So I still maintain that there may be the need for another meeting to iron out the differences. Because I am not a member of the subsidiary legislation, I am unable to go deeper into the matters. I may go appeal that there should be cool heads. We should all be around the document and see what can be changed, what cannot be changed.
Yeah, but what do you do in the interim?
The controversy is about the use of the Ghana card.
Yes.
As it's so identification document for registration. And the sense I get is that they would want to do a day-by-day registration in the commission offices across the country. If you take the CI, the prevailing CI, it says that political parties must have representatives at the registration center or centers. Are the political parties going to send representatives to the EC offices across the country, Monday to Friday? And why do we send political party representatives? Because if Amia Cheme wants to come and register, and Evans is the agent for Party A or Party B, you are able to say that, no, I am not 18 years, or I am not a citizen of Ghana, and therefore I am not eligible to register. You can raise an objection about my prospective registration, which must be recorded and probably later taken a tribunal for adjudication. But once we are going to do a central registration in my constituency, and my party rep or any other party rep is from, let's say, Penkwasi in Sunyani or from Abisim in Sunyani, how would that person know other people coming from other areas in their constituency? Unless we want to say that we are scrapping political party agents at the registration center. And the only way you can make it very clean or solve the problem of infiltration is to use the Ghana card, because it has gone through a system. It may not be foolproof, but at least it can eliminate some of the challenges that you may have if you are doing the registration in the offices of the Electoral Commission. so that anybody who turns 18 works there, whether a party has a rep or doesn't have a rep, the registration can be done.
I mean, so these are suggestions that you have. And how do you propose, and very briefly, how do you propose you get past the Speaker's concerns tonight, which has led him to make this ruling tonight? Should the EC simply come back to the House and seek to engage the leadership and the Speaker, and that should resolve this?
I think an issue was raised by the minority leader. He has a concern. And I understand when they went for business committee yesterday, it was a matter that was raised or discussed at the meeting. So the leadership and the business committee must take it forward.
I'm grateful. That is Mr. Yao Treme, who is a member of the Constitutional Legal Affairs Committee in Parliament. Also, you had Roxanne Dafiamekbo, another member of that Legal Constitutional Affairs Committee in Parliament. Kwesi Ameyao Treme, MP for Sunyani East, speaking to us, calling for Comhurst to prevail. The Electoral Commission, they tell us that they have engaged. They have engaged two committees in the House. And they expect that this legislation, the constitutional instrument, should formally go through. And now know that they are also attempting to engage the leadership of the House to try and resolve this impasse. Listening to Top Stories on Joy 99.7 FM. Newsnight starts. Ghana Connect starts right now.